Thank you very much. I would like to begin by expressing how honored I am to testify before the Inter-American Court of Human Rights. The Court's judgments on the rights of indigenous peoples are held in the highest esteem and are often cited in the work of the various United Nations mechanisms that I have been part of for more than a decade. For instance, I recall in 2008, when I was the chairperson of the United Nations Permanent Forum on Indigenous Issues, we publicly welcomed the Court's judgment in the case of Saramacca people. I will begin with the Convention on Biological Diversity, which has been ratified by 194 states. Protected areas are one of the main issues addressed under the CBD, and I would like to highlight Decision 7/28 adopted by the Conference of Parties in 2004. It provides in pertinent part that the establishment, management, and monitoring of protected areas should take place with the full and effective participation of and full respect for the rights of indigenous peoples, consistent with national law and applicable international obligations. This language has been repeatedly affirmed by the Conference of Parties, for example, in its decision defining the ecosystem approach and adopting the Addis Ababa Principles on Sustainable Use in 2004. These decisions require respect for indigenous peoples' rights and additionally subject the establishment and management of protected areas in compliance with a state's obligation under international human rights law. This is recognition by the state parties to the CBD that protected areas have often resulted in grave violations of indigenous peoples' rights and that they should not be treated any differently than any other activity that may affect indigenous peoples' territories. In this respect, the CBD decisions have also highlighted the recognition of indigenous-owned and managed protected areas as an alternative and effective way of protecting biodiversity. These decisions are also reinforced in the text of the Convention, in particular Article 10C, which requires that state parties shall, quote, protect and encourage indigenous peoples' customary use of biological resources in accordance with traditional cultural practices, unquote. This article should also be read to include protection for rights to lands and resources and to require recognition and protection of indigenous institutions and customary laws. In 2014, the Conference of Parties adopted Decision 12/12 that addresses Article 10C in relation to protected areas. It highlights the requirement that protected areas and management regimes must be consensual if indigenous peoples' rights are to be respected and emphasizes the need for collaborative approach or recognition of indigenous peoples' own conservation initiatives within their territories. I will now turn to the primary international policy standards and best practice on protected areas and indigenous peoples. These standards reflect international consensus that sees respect for indigenous peoples' rights not only as a pressing human rights concern, but also as fundamentally related to the effectiveness of conservation efforts. I recently attended the 2014 World Parks Congress, the primary global forum on protected areas, which is held once each decade. This Congress reaffirmed the decisions taken at the 2003 Congress, which formally instituted what is known as the new protected area paradigm. This paradigm has firmly incorporated into the CBD decisions and programs of work on protected areas that I discussed previously. It also greatly influenced the world's largest non-governmental conservation organizations, all of whom adopted policies in the past 10 years requiring compliance with indigenous peoples' rights and their activities. This new paradigm is explicitly based on full respect for the rights of indigenous peoples in relation to all existing and future protected areas. including their effective participation on decision-making based on their consent, and the establishment of participatory mechanisms for the restitution of indigenous peoples' traditional lands and territories that were incorporated in protected areas without their free and informed consent. These 2003 decisions were based on the premise that, quote, there is an urgent need to reevaluate the wisdom and effectiveness of policies affecting indigenous peoples, unquote. Thus, the old paradigm by which large parts of indigenous territories were essentially expropriated and nationalized and then made subject to coercive measures that often resulted in conflict, impoverishment, and cultural deterioration, not to mention other serious human rights violations, was formally rejected as both incompatible with contemporary understanding of human rights and as ineffective in practice. These points were reinforced in the decisions of the 2014 Congress, which state that working in partnership with and recognizing the collective rights of indigenous peoples underlies the commitment to redress and remedy past and continuing injustices in accord with international agreements, including the restitution of lands where they have been included in protected areas without indigenous peoples' consent. This new paradigm is in part based on in-depth research from numerous sources, some of which is summarized in a 2008 World Bank study. This study explains that, quote, traditional indigenous territories encompass up to 20% of the world's land surface, and they coincide with areas that hold 80% of the planet's biodiversity, unquote. It explains that this is not mere coincidence, as research consistently reveals a strong correlation between indigenous presence and the protection of natural ecosystems, not the least because traditional ways of using and managing biodiversity are grounded in progressive principles of sustainability. The World Bank study also reviewed many World Bank-funded protected area projects and identified key lessons from those projects. These include, first, that recognition of indigenous land rights is strongly related to successful outcomes and conflict avoidance. Second, that empowering indigenous peoples to manage biodiversity in their own territories has resulted in a more sustained and cost-effective way to biodiversity. And third, that countries that directly incorporated indigenous peoples' objectives into biodiversity projects achieved the best results from both a social and environmental perspective. These all seem to be powerful reasons to ensure that indigenous peoples' rights are fully recognized and respected in relation to conservation initiatives, including protected areas, and to put the onus on states to justify why non-consensual protected areas may be strictly necessary within indigenous territories. They also put the burden on states to substantiate that they have rigorously applied the criteria that would allow them to intervene in indigenous territories, including through undertaking participatory assessments of alternatives, as well as to substantiate what they have adopted, that they have adopted adequate measures to respect indigenous people's rights. As can be seen from the CBD decisions, international environmental and human rights laws should not be seen as distinct bodies of law, but as interrelated and complementary. Indeed, the state parties to the CBD have built respect for rights and related international obligations into their decisions on protected areas as they concern indigenous peoples. This is a much welcome development, as I have to say that the UN Rapporteurship on the Rights of Indigenous Peoples has received many complaints about human rights violations in connection with protected areas, as have the treaty bodies. In many cases, allegations of grave harm have been substantiated. The rapporteurship has adhered to the same basic principles enunciated by the Human Rights Committee and the Committee on the Elimination of Racial Discrimination, the latter explicitly in relation to protected areas. These basic principles are, first, that states must recognize and protect the rights of indigenous peoples to own, develop, control, and use their communal lands, territories, and resources. Second, that decision-making in relation to all aspects of protected areas must take place with indigenous peoples' effective participation in their consent where any restrictions on their rights may be proposed, and that this obligation is ongoing. And third, that indigenous peoples have the right to restitution and other forms of redress where their lands have been incorporated into protected areas without their consent. I won't presume to discuss this court's jurisprudence other than to say that it did find a violation of the right to property in connection with a nature reserve in the Samokasek case in 2010 and ruled that the victim's right to recover their lost land remains in effect. In the same year, the African Commission on Human and People's Rights found violations of indigenous people's rights caused by a protected area in Kenya and extensively quoted the court's jurisprudence and Saramaka people to support its decision. I will note some of the main points. The African Commission began by stating that the public interest test is met with a much higher threshold in the case of encroachment of indigenous land, and in particular, that consent must be obtained where a project would have a major impact within their territory. It also explained that a limitation may not erode a right such that the right itself becomes illusory. It held that because the respondent state denied that affected people all legal rights in their ancestral lands, rendered their property rights essentially illusory, and that this cannot be justified with reference to the public interest. To conclude, the Convention on Biological Diversity and its authoritative interpretation by the Conference of Parties fully upholds indigenous people's rights in relation to protected areas and mandates that they be established and managed in full compliance with a state's international obligation. This allows for the application of the full spectrum of the state's human rights obligations, such as those defined by the American Convention on Human Rights and as set forth in the UN Declaration. This is also the consensus reflected in the primary international policy standards and best practice. From what I have seen of the facts in the Kaliña and Lokono people situation, I would say that protected areas in their territory illustrate a considerable deviation from these requirements. These reserves are consistent with the old and discredited paradigm, and so far they are non-consensual and fail to recognize and respect indigenous people's rights, and the state has taken a considerable area of their territory. They are coercive and exclusionary, and the means employed are unnecessary and disproportionate to the asserted public interest, which could be achieved in a different and less drastic way. Also, because they are by law owned by the state, I would classify these reserves as an ongoing, outwardly illegitimate dispossession of indigenous lands that requires redress, not just in relation to property rights, but also with the full spectrum of rights that are interdependent with indigenous peoples' relations to traditional territory. The international authorities strongly support restitution as the appropriate and primary remedy in such situations, in addition to other forms of redress. Thank you very much.